2 U.S. Attorney nominees, 2 U.S. Marshal nominees, the nominee to head the Administrative Conference of the United States, and 2 bipartisan bills on the subject of protecting children against exploitation. S. 3538, the Earn It Act of 2022, introduced by Senators Graham and Blumenthal, and S. 3103, the Eliminating Limits to Justice for Child Sex Abuse Victims Act, introduced by myself and Senator Blackburn. I will focus my opening remarks on one of the nominees, and I'm glad that Senator Blackburn is present because I'm going to speak about the nomination of Andre Mathis, nominated to the Sixth Circuit Court of Appeals. I will then turn to the ranking member, Chuck Grassley, before we proceed to vote on judicial nominees in the order listed on the agenda, and then turn to the bills. As we've done at previous markups, I ask members to wait to comment on a particular nominee until that nominee is up for consideration, and I will certainly recognize anyone who wishes to speak at that time. And be mindful of the length of your remarks as a courtesy to other members of the committee, and so that we can have time to discuss the 2 bills that are pending before the committee today. Turning to today's agenda, we will consider Andre Mathis, nominated to the Sixth Circuit. I want to address 3 points about his nomination: consultation, qualifications, and Tennessee support. As I understand it, the primary objective to Mr. Mathis' nomination relates to consultation. And while I, of course, respect those who have a difference of opinion, the record, I think, shows a meaningful effort at consultation between the White House and the 2 Tennessee senators. Let me lay out the timeline. May 15th, 2021, Judge Bernice Donald of the Sixth Circuit announces her intent to take senior status upon the confirmation of her successor. 2 weeks later, June 4th, 2021, the White House counsel, President Biden's White House counsel's office, reached out to the offices of Senators Blackburn and Hagerty to discuss this vacancy. At that time, the White House signaled its interest in Andre Mathis. Importantly, the White House also requested the senators' views on Mr. Mathis and any additional candidates they might propose. The White House also made Mr. Mathis available personally to meet with Tennessee senators. I have never seen that in my experience, where a nominee at that stage was made available, but they did. On June 17th, 2021, the senators asked their counsels to meet with Mr. Mathis personally. On July 6, 2021, Senator Blackburn's staff emailed the White House, copying Senator Hagerty's staff, confirming that they had met with Mr. Mathis and noting that they had enjoyed the conversation. Notably, the email did not take a position on Mr. Mathis's candidacy. Staff for the 2 senators proposed that the White House consider another person, Judge Camille McMullen, for the vacancy. In the intervening months, the White House did just that. They not only reviewed her record, they met with her personally and interviewed her. In November 2021, a few days before his nomination, the White House contacted the staff for both Tennessee senators and let them know that the White House had chosen Mr. Mathis to be their nominee. On November 18th, 2021, the President formally nominated Mr. Mathis. Now, as I understand it, before the date on Mathis' formal nomination, the Tennessee senators had not indicated to the White House that they would oppose his nomination. They had recommended that the White House consider their candidate, but they never told the White House that Mr. Mathis was unacceptable. With respect to my colleagues from Tennessee, the record of communication and correspondence around this vacancy makes it clear that the White House did engage in meaningful consultation. It is true the President did not ultimately nominate the Tennessee senator's choice, Judge McMullen, but that was the decision for the President to make. I want to put this issue of consultation in historical context. Then Chair Chuck Grassley spoke at a markup on November 30th, 2017 about his decision to proceed with circuit nominees even without a blue slip from home state senators, and he said, "A negative or unreturned blue slip will not necessarily prevent a hearing unless the White House failed to consult with home state senators." But in fact, in the matter of Andre Mathis, the Biden White House did consult with home state senators. In a November 2017 floor speech, then Chair Grassley said, and I quote, "A senator can't use a blue slip to block a nominee because it's not the person the senator would have picked." Under Senator Grassley's stated standard, the fact that the president chose to nominate Mr. Mathis is not a legitimate reason to block a nomination. Finally, let me note that the consultation undertaken by the Biden White House far exceeded consultation afforded by President Trump to several of my Democratic colleagues. True enough, I was able to work with the Trump White House personally to settle on 2 Seventh Circuit nominees, but it wasn't the case for many of my Democratic colleagues who had vacancies in their own states, including members of this committee. Think about what Senators Booker and Menendez faced with the Third Circuit vacancy. In a 2018 letter, then Chair Grassley received a letter from the New Jersey senators who wrote, "The White House did not seek our input in any process related to the selection of Mr. Mathis for the Third Circuit vacancy." And despite that lack of consultation, the committee proceeded with the hearing and a vote on Mr. Mathis' nomination. Mr. Mathis received unanimous Republican support in the committee and unanimous Republican support on the floor. Think also about what Senators Cortez Masto and Rosen faced. On September 18, 2019, the Nevada senators announced the formation of a bipartisan commission to vet candidacies for a vacancy in the Ninth Circuit. 2 days later, the White House announced it was still going to nominate Lawrence Van Dyke for that vacancy, even though Mr. Van Dyke did not even live in the state of Nevada. Numerous other Democrats on this committee faced similar situations. If senators on this committee oppose Mr. Mathis on the merit, so be it. But this much is clear. The White House did engage in meaningful consultation. That consultation exceeds much of what we saw under President Trump. And consistent with the standard established by then Chair Grassley and continued by Chair Graham, we will proceed with a vote on his nomination. Speaking of Mr. Mathis' merits, I would urge my colleagues to look at his record, his qualifications, and his Tennessee support. Born and raised in Memphis, Tennessee, attended the University of Memphis for college and law school, stayed in his hometown where he practiced law ever since, litigated hundreds of civil cases, defended approximately 150 criminal cases as a member of the Criminal Justice Act panel in his district. For those unfamiliar with that act, it means that Mr. Mathis undertook court-appointed representation for indigent defendants, never refusing an appointment other than when there was a conflict of interest. He tried 19 cases to verdict or final judgment, briefed 23 appeals, and argued 10 of them personally. For those who claim this experience is insufficient, I'd urge you to look at the litigation experience of several Trump nominees at the time of their circuit court nominations. For example, at the time of her nomination to the Seventh Circuit, Justice Amy Coney Barrett had never argued an appellate case and had never even appeared as counsel of record in a case before an appellate court. At the time of her nomination to the D.C. Circuit, Naomi Rowe had never argued an appeal or tried a case in any capacity. That didn't stop support from the other side of the aisle unanimously. Mr. Mathis has received a unanimous rating of well qualified from the American Bar Association. I would note that committee Republicans unanimously supported 3 circuit nominees under President Trump who received a rating of not qualified from the ABA. Mr. Mathis is a man of integrity. He has qualifications and experience we saw on full display at his hearing. Let me close by noting briefly the support he enjoys within Tennessee. Fred Smith, founder and CEO of Federal Express, headquartered in Memphis, said, "Andre is truly a credit to the profession of law, and I believe he'll be as much or more a credit to the judiciary." Van Turner, president of the Memphis chapter of the NAACP, also wrote in support of his nomination. Mr. Turner wrote in relevant part, "Mr. Mathis hails from a tough South Memphis neighborhood where statistically he should not be where he is today. However, he persevered, beat the odds, and made it. The great thing about Andre is that despite all this, he always finds a way to get back to his community." I believe Andre Mathis will make a truly superb member of the federal judiciary, and I look forward to voting for his nomination. With that, I turn to Senator Grassley.
I got something I want to put in the record that would be a dispute with what you said about New Jersey, but already got a long statement, so I'm not going to go into that at this point. I'm going to support Judge Slaughter's nomination, so I want to speak about Mr. Mathis. The Tennessee senators worked to find a nominee who they could support. They put forward Judge Camille McMullen, a state court appellate judge who had been appointed by a Democratic governor. Unfortunately, this administration refused to work with them, voting to move Mr. Mathis' nomination would condone the administration's process in this case. That process caused the White House to miss out on a valuable feedback from Tennessee senators who know the legal community in that state. When I was chairman, I made sure the White House had meaningful consultations with members before moving forward. The senators have valid concerns about Mr. Mathis' lack of federal appellate experience and his lack of attention to detail. He made an unusually high number of mistakes in failing to follow the Sixth Circuit rules. Some of those mistakes might be small, but the people of Tennessee aren't going to see it as a little thing if details get missed in deciding their cases. Some have also suggested Mr. Mathis may be moderate on the bench, but he is a fairly junior attorney with a short record. He hasn't worked on cases involving major constitutional issues. Unlike the candidate proposed by the Tennessee senators, he has no body of judicial opinions to review. One thing that we can look at is evidence of his judicial philosophy is the article he wrote in law school. In it, he advocated for federal courts to adopt a new standard for habeas court cases. As Senator Hawley explained at his hearing, that theory of habeas review is radically outside of the mainstream, so his scholarship doesn't support the claim that he would be a moderate. Because of these concerns, I'll be voting no. Turning to the bills that are on the agenda today, so I won't speak again when these bills come up. I'm a co-sponsor of the Earn It Act. This bill makes an important step in holding online service providers accountable for very horrific spread of child sexual abuse material. I've long been a supporter of victims' rights and have fought for efforts that stop the spread of child sexual abuse material. In 2018, I co-sponsored the Stop Enabling Sex Trafficker legislation, commonly known as SISTA, which is designed to hold website operators accountable when they knowingly facilitate sex trafficking. After news reports emerged of sexual abuse of young amateur athletes in 2017, our committee, during my chairmanship, convened a hearing on this subject. I later worked with my colleagues on bipartisan legislation that would make it mandatory for instructors, coaches, and others who work with young athletes to report cases of child sexual abuse to the authorities. I led our committee in reporting this bill, known as the Protecting Young Victims from Sexual Abuse Act, to the full Senate and was later enacted. It's important to find ways to stop the spread of exploitative and sexual material, and this legislation does just that. This common sense bill received unanimous bipartisan support in the Judiciary Committee last Congress, and it's time that we get it on the books to prevent more child exploitation. Eliminating limits to Justice for Child Sex Abuse Victims Act of 2021 will also be considered today. This bill would enable survivors who were victims of over a dozen federal child sex abuse offenses to seek civil damages in federal courts, no matter how long it has taken the survivor to process and disclose the abuse he or she suffered. Delayed disclosure has historically impacted survivors' path to the justice that they deserve. We can't deter children in any way from speaking out against their abusers. We know from the Larry Nassar case and many other tragic examples that it can take years for survivors to muster up the courage to come forward. This bill sends a clear message to victims of these horrendous crimes that we see, we hear, and we support you. Now I'm going to go to something that the Justice Department is sick and tired of me talking about, but I'm not talking about it. I'd like also to discuss examples of the Justice Department's failure to respond to this committee's oversight request. On February 3 last week, the Justice Department purported to respond to 5 of my oversight letters in a single letter. The department also noted that since January 20th, 2021, I have, quote, written or joined approximately 50 letters to the department, representing about 1/3 of all the letters the department receives from members of the United States Senate, end of quote. Now, I doubt that Garland said that as a compliment. In that letter, the department noted that I provided a binder of unanswered letters to the Attorney General Garland during his confirmation, and I simply did that so he wouldn't be blamed for a lot of things that the Trump administration didn't respond to. The department noted that it responded to those letters. Now, in that case, the department is dead wrong. My staff made clear to the department last year that its so-called responses included non-responsive letters that I've had for years. The department essentially reissued the same letters. Second, new response letters that failed to fully answer the questions posed. You can put words on a piece of paper, that doesn't mean you're responsive. And third and last, the department failed to provide a single page of responsive records. As to the 5 letters the department said it responded to in that single letter, they failed there as well. As part of my and Senator Johnson's ongoing investigation into the Biden family's foreign business deals, we asked for FISA information on Patrick Ho. You've heard me talk about Patrick Ho before. He was connected to the Chinese government's intelligence services. Hunter Biden reportedly represented him for $1 million. The department confirmed in federal court. Now, let me say that again. The department confirmed in federal court that it has FISA information on Patrick Ho. But the department wrote a letter to me and Senator Johnson saying that it couldn't confirm the same. The department again refused to explain why Attorney General won't say whether Nicholas McQuaid is recused from Hunter Biden's criminal case. Yet the department has publicly confirmed that other employees are not involved in other criminal cases. The department again refused to answer about Mueller team wiping their government phones data. However, after pulling teeth to get documents from the department, it provided records to me. Unfortunately, those records were filled with improper FOIA redactions, and they didn't include the necessary spreadsheets. And I also want to know if career employees were consulted when the Biden administration said it's very weak crime policy, because if career employees weren't, then it would indicate possible political considerations infected the process. No answer on that question. As to my letter on COVID-19 and nursing home investigations, the department is hiding behind the policy that it doesn't comment on ongoing investigations. All we know, as we all know, the department can speak to ongoing investigations if they're in the public interest. So the Biden Justice Department has essentially taken the position that COVID-19 and nursing home deaths aren't in the public interest. Now, simply put, the department conduct is a complete embarrassment. Their conduct is a slap in the face to this committee. So Chairman Durbin, say it again to this, this committee must assert its constitutional oversight authority on the Justice Department. Thank you very much.
Thank you, Senator Grassley. This recurring issue of response to letters, we know that the department did respond, and you noted that as well in your statement here. The department says that it received 50 letters from you last year and has responded to 40 of those letters as of yesterday. I am going to continue to insist that the department respond to every letter that they receive from you and members of the committee, and I hope that we can have a timely response to that. I'll also insist that the Department of Justice improve its responsiveness to questions for record. And, excuse me, Senator. It's an issue that has long been before this committee. I'll give you an example. By my staff's count, from 2018 to 2020, 35 witnesses from the Trump administration Justice Department testified before this committee, and questions for record were only returned from 5 of the 35. So the Biden response has been better. We're going to hold them to an even higher standard. I hope that they will meet it.
15 seconds.
Sure, you got it.
Those are words on a paper. They are not responses. And I've said many times, doesn't matter whether it's a Republican or Democrat administration, and I will agree with you that Trump's didn't respond as he should, and maybe I wasn't fully as aggressive as it makes it sound like I was now with this department. But whether it's Republican or Democrat, I expect people to do it, and I've even stood up for Democrats in the Trump administration when they said they didn't have to respond to minority or ranking member letters, and I even testified in the House of Representatives that we were going to defend both Republicans and Democrats in that process.
You are consistent and tenacious. We know it. I respect you for it.
Thank you.
I'd like to address one other issue that was raised in relation to Andre Mathis by Senator Grassley in his opening statement here. The statement is made that Mr. Mathis is not qualified because he had to refile several briefs with the Sixth Circuit in order to correct issues that they raised. In fact, it's been said if Mr. Mathis can't follow the Sixth Circuit's rules, how can we have any confidence that he can serve on this court? So we took a look at 2 specific issues. Case Berkeley versus Williams, 2021. It turns out that Mr. Mathis was asked to refile a brief in one case in order to make it a non-modifiable PDF as opposed to a modifiable PDF. That is one of the issues that's being raised about his disqualification from circuit court. Another case, United States versus Starks. Mr. Mathis's brief was missing a page designating the relevant district court document. The court asked him to refile the brief with the additional information. He did it. When he was asked about these things and appearing before this committee, he didn't pass the buck. He didn't blame a paralegal. He accepted responsibility for what was filed. Any of us who have filed legal documents before a court know that sometimes there's a deadline and a voluminous requirement, and we do our level best, and sometimes we miss a detail. These 2 are details that he complied with when the court asked him to, and I don't think are an indication that he is unqualified to serve on the circuit court. Does anyone seek recognition to speak on Mr. Mathis' nomination to the Sixth Circuit? The senator from Tennessee.
Thank you, Mr. Chairman. Mr. Mathis' nomination is precedent-setting. This is the Biden administration's first circuit nominee in a state with a Republican senator, and in this case, it is 2 Republican senators. And the way the White House has handled this nomination from start to finish has made one thing clear, very clear. The Biden White House has eliminated the role of home state senators in the nomination process. And I'm not going to take up the committee's time rehashing the White House or this committee's process failures on this nomination. I will just say this. Senator Hagerty and I were not given meaningful consultation on the nomination. What we did hear from the street talk in Memphis was that the Senate was irrelevant, the home state senators were irrelevant. It is as simple as that. I know that some members of this committee feel that they were not adequately consulted by prior administrations on judicial vacancies in their states, and I understand that some of you are still upset about that and think that process arguments went out the window a long time ago. But this isn't just about lack of process. The consultation process exists in large part to ensure that we fill judicial vacancies with well-qualified, experienced candidates who are up to the task of upholding the rule of law. Mr. Mathis's nomination is a paradigm for what that process is needed. When the home state senators are not consulted, we end up with an unqualified candidate. I was finally given an opportunity to meet with Mr. Mathis personally earlier this month. It was after his hearing. And I've talked with some of his colleagues and friends, and it seems like he is a very nice man with a lovely family and a community that support him. But after reviewing the record, observing his performance at his hearing, and meeting with him one-on-one to discuss his knowledge and view of the law, there is no question in my mind that Mr. Mathis is unqualified for the position on the federal bench. I do have concerns about his ability to do the job of a federal appellate judge. During my one-on-one meeting with him, he couldn't answer basic questions about the Constitution, including the Second Amendment. He also wrote an article, which Senator Grassley referenced, advocating for a freestanding actual innocence claim when it comes to federal habeas petitions. This would allow a convicted defendant to relitigate his case at any time if he believes he has enough evidence to prove his innocence. When Senator Hawley asked him about this article during his hearing, he would not say whether he still supported that idea. This is incredibly concerning to me and should be concerning to any member of this committee who cares about finality with the rule of law. Mr. Mathis has also never argued a federal appellate case. On the appellate briefs he has actually worked on, he's been the local counsel. Mr. Mathis is not the lead attorney handling the substantive appellate issues. He's the local counsel in charge of ensuring compliance with the local rules. And of the 9 Sixth Circuit briefs that you had previously mentioned, Mr. Chairman, he's worked on 8. 8 were kicked back for failure to follow the local rules. That is 8 out of 9. His job as local counsel was to comply with the local rules. Perhaps even more telling is the fact that his own clients don't see him as an appellate lawyer. When a case he is working on goes on appeal, his clients bring in other appellate lawyers to handle it. That can only mean one thing. His clients don't trust him to handle appellate matters before the Sixth Circuit. In fact, his own firm doesn't see him as an appellate lawyer. Butler Snow, where Mr. Mathis is a partner, does not list him as part of their appellate practice group. If his own clients, his own firm, don't trust him to handle appellate work, how can we trust him to handle appellate cases on the Sixth Circuit? It would be a disservice to the people of Tennessee and to the people of the other Sixth Circuit states to give him a judge with lifetime tenure who is clearly not qualified. I ask all of my colleagues to remember this. One day soon, maybe sooner than you think, they very well could be in a position that I'm finding myself in. One day there might be a vacancy in their state, and the White House will try to fill it with a patently unqualified candidate whom they hope will do their bidding on the bench. I ask you all to stand with me today to preserve the integrity of the federal bench. Thank you.
Thank you, Senator. Before I recognize Senator Kennedy, I want to enter into the record a letter from that same Butler Snow law firm that Mr. Mathis works in, of January 7th, 2022, and to quote it in part. And I quote, that Andre has distinguished himself as a trial lawyer at our firm, where former U.S. attorneys and fellows of the American College of Trial Lawyers lead our litigation practice, is significant. In an era of disappearing trials, Andre has had 19. He has also argued 10 of some 24 appeals that he has briefed. This quantum of experience is enhanced by its quality. Cases in both federal and state courts involving civil and criminal claims. I won't go on to read the letter. I'll put the letter into the record. Senator Kennedy, without objection. And then Senator Padilla.
Mr. Chairman, thank you. With respect to the consultation between the White House and Senator Blackburn and Senator Hagerty about Mr. Mathis's nomination, I am not saying, Mr. Chairman, that the facts as you see them and as you set them forth in your opening statement are inaccurate. The truth is, I don't know. I do know that there is a difference between consultation and good faith consultation, perfunctory consultation and good faith consultation. I am saying that I believe Senator Blackburn and I believe Senator Hagerty when they tell me that the consultation that they received was not meaningful. I'm also suggesting, with respect, Mr. Chairman, this is not only true of the President Biden's administration, but any administration for that matter. It makes no sense to me why the executive branch wants to lead with its chin and not meaningfully consider the opinion of the home state senators. By not doing that, you automatically start out 2 votes down, and that makes no sense to me. And I would like to, I wanted to make my feelings known and clear for the record. Thank you, Mr. Chairman.
Thank you, Senator Kennedy. Senator Padilla.
Thank you, Mr. Chair. Appreciate the opportunity to make a statement prior to voting. I do also want to briefly comment on Mr. Mathis's confirmation process. I'm proud to support Mr. Mathis's nomination to the Sixth Circuit. His record shows clearly that he's well prepared to take on the role and that he will faithfully apply the Constitution as a federal appellate judge. Mr. Chairman, I support the use of our confirmation hearings to ask important questions about the backgrounds, the views, and the qualifications of judicial nominees who are about to take arguably some of the most important offices in the country. Senators should do our part in that advice and consent process. But I have to say that I was particularly troubled by some of the treatment that Mr. Mathis was subjected to during the hearing. During the hearing, Mr. Mathis was asked to answer for his quote-unquote rap sheet with a quote-unquote laundry list of citations. So let's be clear. Mr. Mathis is not a career criminal or violent felon. as the question implied. He has never been arrested or convicted of a crime. The underlying issue being commented on was traffic violations dating over a decade ago. Whether it was unintentional or intentional, questions and tones like what I heard during his hearing are demeaning, offensive, and just plain wrong. These attacks also undermine public confidence in the judiciary and sometimes can incite harassment against the nominees who appear before us. And Mr. Mathis, unfortunately, isn't the only nominee to receive this kind of treatment. It's not lost on me that nominees of color that have been treated differently in our hearings, whether it's insinuations of a rap sheet or hostility about their qualifications or views or undue scrutiny of their personal religious faith. Now, I'm not saying it's been every nominee, and I'm not saying it's been every member of this committee, but I want to take this moment to ask all of my colleagues to please, let's just be cognizant of this disparity. The Senate Judiciary Committee has made remarkable progress by many measures this past year, including confirming a historically diverse group of nominees. And I thank you, Mr. Chair. I thank Ranking Member Grassley for leading us in that effort. And I'm thankful to my colleagues who have recommended such a diverse group of qualified and more than qualified individuals for federal judgeship. I'm grateful for Senator Graham and others who have already spoken up in support of building a more diverse judiciary that better reflects the nation that it serves all the way to the Supreme Court. And I hope that we keep up that effort today and going forward. We should be mindful of our word choice out of respect for the nominees who come before us and the world that's watching. Thank you, Mr. Chair.
Thank you, Senator Padilla. And let me just add as a footnote, one of our recent nominees who appeared before this committee faced tough questioning, and whether it went too far will be someone else's judgment. And then one of our members of our committee tweeted in reference to the question and answer. The net result of it was threats to the family of this nominee. I don't think any of us want to see that happen. I would join in Senator Padilla's request that we be respectful and still discharge our duties within the committee. Is there anyone else seeking recognition on Andre Mathis' nomination? Senator Lee.
I want to echo the concerns that have been raised by several members of the committee as to the process. I share those concerns and share concerns on the merits of the nomination. I'm deeply sympathetic to the idea that obviously everyone needs to be careful about their comments and not inciting other people to carry out disrespectful and potentially harmful actions in response to someone. And to that very end, the need to be respectful applies also with respect to colleagues. Comments made a moment ago by a member of our committee, I hope I misunderstood them, to the extent he was suggesting racial bias on the part of members of this committee. I know that to be grossly inaccurate, extraordinarily unfair, and also of the very sort of comment that would incite people to anger, acts of retaliation, and violence. Look, collegiality requires better than that. I hope I misunderstood the comments of our colleague. Either way, to accuse colleagues who disagree with you of racism is a very serious thing.
Anyone else seek recognition? Senator Hawley.
I had not intended to speak, Mr. Chairman, but I have to agree with Senator Lee. I mean, to accuse members of this committee of racism because you disagree with them on substance, I think it is a very serious thing. And frankly, I'm startled to hear it. And I hope that I also misunderstood. But I know that that's common practice in the media. I know that it's become a common campaign tactic. I know it's become a common political tactic. But frankly, it's reprehensible, and I think it's wrong. And I think it is highly destructive of any efforts at bipartisanship and consensus building. And I just have to say I'm deeply disappointed by it.
Mr. Chairman, just really quickly.
Senator Booker.
Yeah, I've heard the comments of folks, and I really understand them. I actually have a deep empathy for people who weren't consulted about their home state senator, their home senators not being consulted on a circuit court judge. And I just offer to my colleagues, many of whom are friends, to have a constructive conversation, because the exact same thing was happened to Senator Menendez and I. Stunning, in fact, because we asked for meetings, we asked for consultation, we offered up other judges. And so I think it's wrong. I think the turn we took with circuit judges under the Trump administration was a wrong turn for this committee. I don't know how you put the toothpaste back in the tube, but we've seen this erosion of norms within this committee and within the United States Senate, and I know that there are good faith folks on the other side who are concerned about this, and I just offer conversations, because this will continue as we continue to slingshot back and forth between chairmanships of this committee and presidents in the White House. And it's unfortunate that this norm has now slipped through our fingers. I don't know how to get it back, but I'd love to have a conversation with my colleagues on it.
Mr. Chairman.
Senator Cornyn.
Mr. Chairman, let me join Senator Blackburn and Senator Hagerty in protesting the lack of consultation and communication on circuit court nominees. My understanding was during the previous administration and with under Chairman Grassley that no senator was provided the opportunity to veto a nominee by the president to a circuit court. But there was aggressive attempts at consultation, which were by and large very successful, to hear the concerns of the home state senators and to talk about it and give them a sense that they were being included as opposed to being given the Heisman when it came to these nominations. And I just suggest that a little bit of comity and consultation will go a long way to improving the atmosphere and the judicial confirmation process, which have become famously embittered over time, particularly at the Supreme Court level, but also creeping now into the circuit court nominees. My understanding is the chairman continues to honor the blue slip for district court judges, which means that any home state senator can effectively block a nominee to the federal district court by the Biden administration, should they choose to do so by not returning their blue slip. The practice, of course, as I said, under the previous administration and previous chairman, was that that did not extend to circuit court nominees. And I understand that, and I would expect there to be reciprocity. But let the record be clear, there were aggressive attempts at consultation and communication with Democratic senators under the previous Republican administration when it came to circuit court nominees. The fact that they were unsuccessful in persuading the administration not to nominate somebody is not the equivalent of not consulting and not communicating. And I understand, well, maybe the attitude is we don't have to and you can't make us. But I think that poisons the well when it comes to the sort of dignified and civil process that I would hope that we would aspire to here. Certainly we failed on many occasions to achieve that, but I think that ought to be our collective aspiration. And particularly when we have a 50-50 Senate and the lack of consultation with Senator Blackburn and Senator Hagerty on this circuit court nominee, this is not going to be the final word here in the committee. We all hope for Senator Lujan's quick return to the Senate. We wish him well, hope him a speedy recovery. But it demonstrates the fragility of a 50-50 Senate. And if you're Andre Mathis, who I've heard good things about from some of our former colleagues, if his nomination fails because the White House has poisoned the well with senators and basically guaranteed a reflexive opposition to his nomination because of a lack of consultation and communication, I think that's unfair to Mr. Mathis too, and it's unfair to any future nominees. So I think there's a lot of incentive for us to try to treat each other with reciprocity. And I just want to correct what I understand the record to be is that there, under Chairman Grassley, there was always, and Chairman Graham, always communication and consultation when it came to circuit court nominees, and certainly under Senator Leahy when he was chairman as well. So I just think that ought to be the standard we aspire to, because I think our failure to reach that, to achieve that aspiration, I think will have concrete and negative consequences going forward. Thank you.
If I can just do a quick response for the record, forgive me, Chairman, especially because he mentioned the Heisman, and as the only senator here, I think, that was given a Heisman trophy to hold for a few minutes before I had to give it back. I just want to correct for the record.
We were going to do a fact check.
I just want to correct for the record. I was not given by the last administration the courtesy that was given to Senator Blackburn. I beseeched them to let me meet with their candidate before the hearing here or before the committee vote, and we were denied that opportunity. We did eventually get to meet with him before the floor vote, but we felt continually through the process, we made appeals, and those were not honored. I'm not here to go back and forth on those facts. I'm simply here to say I agree with you, Senator Cornyn, about what I consider just a simple courtesy for us to do our constitutional duty of advising and consenting. And I'm very frustrated about how we were treated, and I do agree with you what the standard should be.
Well, Mr. Chairman, I'm sorry to hear that the senator doesn't feel like he was consulted or treated with that standard that we've said we should all aspire to, and that. But I have no knowledge of the circumstances. I'll just have to rely on your statement. But again, that doesn't change the fact that if there is no consultation and no communication with home state senators, what incentive do they have to cooperate with and support a nomination? And I would hope the Biden administration would see some wisdom in trying to eliminate sort of reflexive opposition because of a process foul, and would try to encourage all of us to aspire to the goal that I share with Senator Booker in terms of consultation and communication. Thank you.
Now we have requests from Senator Whitehouse and Leahy. Senator Whitehouse.
Thank you, Chairman. The experience of members of this committee has been stated by the members of the committee as to the extent of Trump administration consultation regarding circuit court judges. And I think we should heed those statements of fact by our fellow members. We can litigate endlessly the sincerity of consultation between the White House and members, whether it's for real or whether it's for show. It's very hard for us to police that. If we had blue slips, that would not be a problem. We are living today with the consequences of getting rid of the blue slip for circuit court nominees. I got to say, I warned about this over and over and over again and urged my colleagues not to do this. I said, I really think you ought to think long and hard about this, because once you tear down a tradition like this, it's really hard to rebuild it. I warned about its effect on the members who have commissions that make recommendations to them for courts, often bipartisan ones. With this vote, this committee has just killed the blue slip for circuit court nominees. We shot a torpedo into the very often bipartisan selection committee process that a great many senators have agreed to in their home states. And then, in response to what happened in California, I pointed out that not only do we not have any voice over who gets appointed to the circuit court associated with our state, we don't even have the power to assure that it's somebody associated with our state. We have senators on this committee who believed that the appointee had no credible association with their state. And I warned actually about, I think it probably had Senator Kennedy in my eyesight, and I mentioned about, appointing a nice Brooklyn judge to a Louisiana seat. We have lost something very important when we undid the blue slip. To Senator Booker's point, I don't know how you put the toothpaste back in the tube. I'm eager to help find a way, but I will tell you what that way cannot be. It cannot be that when there's a Democratic president, everybody gets a blue slip and it can be used to block circuit court nominees. And where there's a Republican president, the Federalist Society cranks up its turnstile, big donors choose the nominees, and everybody lines up and shoves them through irrespective of qualifications or blue slips. That's how it happened in the last administration, and we can't have a back and forth. Whatever our solution it is, has to be something that will stick. And let me just say, with regard to the Federalist Society judicial selection turnstile, if you look at Judge Barrett when she went onto the circuit, if you look at other judges, I had a list in front of me and I've mislaid it. Here it is. If you add up Judge Walker, Judge Rao, and Judge Barrett, their experience when they were put onto circuit courts, as a sum number, it is less than the experience of the judge we're debating today. So the debate over whether he has enough experience is a wondrous thing to me, having watched those three judges dialed through the Federalist Society turnstile and onto circuit courts with far, 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 far less experience than this judge exhibits. So we are in a bad place on this, and I'd like to get out of it, but let me just put those guardrails down. It cannot be that the way we get out of this is that there are blue slips when there's a Democratic president, and it's Federalist Society turnstile with no blue slips when it's a Republican president. Thank you.
Leahy?
Mr. Chairman, I hesitate to speak on some of these things from an historical point of view, but you have two senators who have different philosophies, Senator Cornyn and Senator Whitehouse, and I say that respectfully, but I would say that we should listen to what both Senator Cornyn and Senator Whitehouse said. I worry about what is happening as the traditions break down, and the Senator Whitehouse is absolutely right. You can't have one for a Democratic president, a different one for a Republican president. I was chairman with both Democratic and Republican presidents. And I believe everybody agreed that I established the same positions during that time. And things went better. I think I would note that I have voted for more Republican nominees to the federal court, district, appellate, and Supreme Court than virtually every Republican member of this committee. And I've also voted against ones I felt should not be there. But you ought to be in a position where you can, when it's your home state, you should have a lot of say what goes in, or at least consultation. district courts, it's usually pretty well done, U.S. attorneys, things like that. But I worry that in the last administration, so much of the traditions that Republicans and Democrats have relied upon fell apart. I think Senator Cornyn is right in saying that we have to have this comity. Senator Whitehouse is right. And I worry, I mean, I will not be here to see what happens, but I worry about the polarization that goes on. I worry about the charges made against some nominees, which seem to be, in some cases, thinly veiled charges because they're a woman or a person of color. I think we've got to get back, as the Judiciary Committee, Republicans and Democrats alike, showing we care about who's in a federal judiciary. I tried a lot of cases before federal courts, both trial courts and courts of appeals. I never once looked at a court and had to think, well, this judge is going to take a different view toward me because I was a Democrat, either for or against me. Back at that time, they were virtually all Republican nominees because that's all we'd ever had from Vermont. But I knew I'd be treated fairly. I worry that if we set standards that get too polarized, the credibility of our federal courts suffers. The credibility of our Supreme Court is already suffering. We see it in the polls. And if people think our federal courts are unnecessarily politicized, this country faces real difficulty. With that, I'll yield.
Thanks, Senator Leahy. We've taken the first hour of the committee on this, but I think it's important that this dialogue take place. I'll just say for the record, I think Senator Whitehouse has identified the dilemma. We're certainly not going to wave a white flag and change the blue slip rule as to circuit nominees since we have a Democratic president, but I will insist that this administration consult with members of the Republican side in the appropriate cases involving states where there are Republican senators. I do believe that it happened in this case with Mr. Mathis, and there'll just be a difference of opinion with myself and the senator from Tennessee, whom I like a lot. I think she's a good member of this committee, and I count her as a friend. So if nothing further is to be added, I'm going to ask that on favorably reporting the nomination of Andre Mathis to be U.S. Circuit Judge for the Sixth Circuit. The clerk will call the roll.
Mr. Leahy. Aye. Mrs. Feinstein. Aye. Mr. Whitehouse. Aye. Ms. Klobuchar. Mr. Coons. Aye. Mr. Blumenthal. Aye. Ms. Hirono. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Grassley.
No.
Mr. Graham.
No, but proxy.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz.
No by proxy.
Mr. Sass.
No by proxy.
Mr. Hawley. Mr. Cotton. Mr. Kennedy. Aye. Mr. Tillis.
No by proxy.
Mrs. Blackburn. Chair Durbin.
Aye.
Chair Durbin, the votes are 12 yeas, 10 nays.
The nomination will be favorably reported to the floor, and now the nomination of Jessica Clark to the U.S. District Court for the Southern District of New York. Does anyone seek recognition? If not, on favorably reporting the nomination of Jessica G.L. Clark to be U.S. District Judge for the Southern District of New York, the clerk will call the roll.
Mr. Leahy. Aye. Mrs. Feinstein. Aye. Mr. Whitehouse. Aye. Ms. Klobuchar. Aye. Mr. Coons. Aye. Mr. Blumenthal. Aye. Ms. Hirono. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff. Mr. Grassley.
No.
Mr. Graham.
No by proxy.
Mr. Cornyn.
No by proxy.
Mr. Lee.
No.
Mr. Cruz.
No by proxy.
Mr. Sass.
No by proxy.
Mr. Hawley? Mr. Cotton? Mr. Kennedy? Mr. Tillis?
No by proxy.
Mrs. Blackburn? Chair Durbin?
Aye.
Sorry, I wrote it in my, sorry, it's, 11 yeas, 11 nays.
The committee has recorded a tie vote on Mr. Gonzalez' nomination to the U.S. District Judge for the Eastern District of New York. Oh, I'm sorry. Excuse me. The committee has recorded a tie vote on Ms. Clark's nomination to be U.S. District Judge for the Southern District of New York pursuant to Section 3, subsection 1A of Senate Resolution 27 of the 117th Congress. I will transmit to the Secretary of the Senate a notice of this tie vote. Under Section 3, subsection 1B of that resolution, either the majority or minority leader may then make a motion to discharge the nomination. Next is Hector Gonzalez, nominated to the Eastern District of New York. Does anyone seek recognition? If not, on favorably reporting the nomination of Hector Gonzalez to be U.S. District Judge for the Eastern District of New York, the clerk will call the roll.
Mr. Leahy?
Aye.
Mrs. Feinstein? Aye. Mr. Whitehouse? Aye. Ms. Klobuchar? Aye. Mr. Coons? Aye. Mr. Blumenthal? Aye. Ms. Hirono? Mr. Booker?
Aye.
Mr. Padilla?
Aye.
Mr. Ossoff?
Aye.
Mr. Grassley?
No.
Mr. Graham?
Aye by proxy.
Mr. Cornyn? No. Mr. Lee?
No.
Mr. Cruz?
No by proxy.
Mr. Sass?
No by proxy.
Mr. Hawley? No. Mr. Cotton? No. Mr. Kennedy? No. Mr. Tillis?
Aye by proxy.
Mrs. Blackburn? Chair Durbin?
Aye.
Chair Durbin, the votes are 13 yeas, 9 nays.
The nomination will be favorably reported to the floor. The last of the judicial nominees up for vote today is Judge Fred Slaughter, nominated to the Central District of California. Does anyone seek recognition related to this nominee? If not, on favorably reporting the nomination of Fred Slaughter to be U.S. District Judge for the Central District of California, the clerk will call the roll.
Mr. Leahy?
Aye.
Mrs. Feinstein? Aye. Mr. Whitehouse? Aye. Ms. Klobuchar? Mr. Coons? Mr. Blumenthal? Ms. Hirono? Mr. Booker? Mr. Padilla? Mr. Ossoff? Mr. Grassley?
Aye.
Mr. Graham?
Aye by proxy.
Mr. Cornyn? Mr. Lee? Mr. Cruz?
No by proxy.
Mr. Sass?
No by proxy.
Mr. Hawley? Mr. Cotton? Mr. Kennedy? Mr. Tillis?
Aye by proxy.
Mrs. Blackburn? Chair Durbin?
Aye.
Chair Durbin, the votes are 15 yeas, 7 nays.
The nomination will be favorably reported to the floor. We're also voting on 2 U.S. attorneys and 2 U.S. marshals. The U.S. attorneys are Marissa Darden, Northern District of Ohio, Delia Smith for the District of Virgin Islands. 2 U.S. marshals are Eddie Frizzell for the District of Minnesota and LaDon Reynolds for the Northern District of Illinois. I'll just say a word about Chief Reynolds. He's been Chief of Police in Oak Park, Illinois since 2019. He served with the Oak Park Police Department since 1994. Well respected in his field of law enforcement, and I think he will do an admirable job. I might note that this U.S. Marshal's position in the Northern District of Illinois has been vacant since May 2018. We are facing serious problems with gun violence and crime in the Northern District of Illinois, and we need all hands on deck. A man of Chief Reynolds' experience is long overdue, and I hope we'll do everything we can to bring him to vote soon. Does anyone seek recognition to speak on any of these nominees? Senator Cotton.
Mr. Chairman, I want to address these nominees since I'm the reason they were held over from last week. and I'll continue to hold over all department nominees, and I'll continue to insist on regular order in the floor until the Department of Justice stands up for the men and women of law enforcement. In the summer of 2020, left-wing street militias attacked the Portland courthouse for weeks on end. U.S. Marshals defended that courthouse. They had to confront fireworks being shot at them, ball bearings being thrown at them, lasers being shot at their eyes, attempts to seal them in the courthouse and burn it to the ground. Now, left-wing activists are suing the deputy marshals who spent months on the front lines defending the courthouse. And the Department of Justice confirmed to me last night in a letter that they are not currently representing 4 of the U.S. Marshals who defended that. They gave no reason whatsoever. They've given no reason to those 4 deputy marshals either. Now, you may say that, well, they're under investigation or they did something wrong, but all 4 of those deputy U.S. Marshals are currently on unrestricted active duty. That means we trust them to guard our courthouses and our judges, to go out in society and try to capture fugitives, to protect witnesses in the Witness Protection Program, to guard dignitaries. Yet the Department of Justice refuses to pay for their legal fees or to provide them counsel in civil lawsuits against them for actions taken in the line of duty. I'd also point out this is happening right as we learn that the Department of Justice sought a greatly reduced sentence for Mathis, a career criminal who committed arson in the BLM riots in Minneapolis that resulted in the death of a father of 5. The sentencing guidelines called for a 20-year sentence. The Department of Justice sought barely half of that, and in their sentencing document, they cited the fact that he was engaged in a social protest, giving voice to the voiceless, a man who burned alive a father of 5. At a time that they are hanging out to dry GS-11 and GS-13 police, exposing them to financial ruin and bankruptcy because they defended federal property in Portland. We all warned when the president nominated Vanita Gupta, and this Senate confirmed her, that the department would wage a war on the police, and that's exactly what they're doing right now. So until the department agrees to represent these 4 U.S. Marshals, or they give a satisfactory answer for why they are not, then I will not allow any nominee to be fast-tracked through this committee or on the floor.
I'd like to address that for a moment. I don't know much about this case that you noted. The death of Oscar Stewart was certainly tragic, and Montez Lee was appropriately prosecuted for the arson that led to his death. But before I discuss any circumstances of this case, let me be clear. The U.S. Attorney nominee, Andre Lugar, had nothing to do with this. And yet he is the one who's being asked to pay a price, not just him, but the people who would be represented by his good offices. At a time when we're all giving speeches about law enforcement and our respect for police and law enforcement, you are showing your respect for law enforcement by telling me in the Northern District of Illinois I have to wait on the appointment of U.S. Marshal. This is a professional lawman who has been given this position. No one has questioned his qualifications. You are not just punishing him, but you're really striking out at a situation in my state that desperately needs attention, and that is law enforcement to stop the gun violence and death. How can this be in honor of U.S. Marshals when you're holding up a U.S. Marshal?
Mr. Chairman, I'd point out that, as you said, this office has been vacant for almost 3 years, since April 2018. So if it was such an urgent priority, you could have gone to Donald Trump in the summer of 2018 and asked him to appoint a U.S. Marshal.
Of course, President Trump just waited for my recommendations. I will tell you that they didn't consider it a priority. And that's a mistake that's not being made by this president. If you're going to make a speech about the violent crime and the death statistics that we're seeing across the United States, you cannot make that speech and hold up the U.S. Marshal that I need in the Northern District of Illinois to execute the duties of that office. It's long overdue. Don't punish my people I represent who are looking for law enforcement at the highest professional level by denying them a U.S. Marshal one day because of your concern about some other case in another state. That is not fair to my state, and it's not fair to this committee.
The people being punished are 4 career law enforcement officers GS-11s and GS-13s who've been hung out to dry by this department. Why are they not being provided representation, as is the department's custom and practice?
Plead your case, but don't take it out on innocent people. Don't take it out on law enforcement.
People who are innocent here are police who are facing the threat of financial
And so
ruin.
you are holding up a U.S. Marshal for the Northern District of Illinois, my law enforcement official that I need to protest the treatment of law enforcement officials in other states? How can that possibly be fair?
Okay, Senator Durbin.
Senator Klobuchar.
I've been discussing this with Senator Cotton. I will continue to do that. And I just want to make the case for these two nominees in Minnesota. Number one, Andy Lugar, who you just mentioned, Mr. Chair, was not in the office when this decision was made on the sentencing case, but he was in the office previously and has a respect of law enforcement across our state. He earned the respect of law enforcement, took on sex traffickers, major white-collar offenders. He led a team of prosecutors, local police, and federal investigators to put Jacob Wetterling's, one of the most notorious missing children cases in our country, to put his killer behind bars, a case that had eluded law enforcement for decades. And in fact, Mr. Chair, when President Trump came into office, I had extensive discussions with his counsel, Don McGahn. And I know that Andy Lugar, when they had terminated the U.S. attorneys across the country, was one of only a few that they actually wanted to rehire. And these are direct discussions with me and Mr. McGahn because of Andy Lugar's great respect. Andy Lugar ended up not retaining that job, but now he is willing to come back. And he has been waiting and had to stop his activities with his law firm because after he got through this committee, he was ready to go back and manage the office. And he believes that office needs managing and wants to get into the office. And so holding him up serves no purpose at all when it comes to issues that were raised in Minnesota. The second one is the one we're considering today, Eddie Frizzell, 30 years of experience in law enforcement, chief of police for Metro Transit in the Twin Cities, and also a 30-year veteran of the Minnesota Army National Guard, including 2 overseas deployments, one to Bosnia and another to Kuwait and Iraq. These are the 2 men that are being held up in Minnesota at a time where we need leadership in place in our state. So I am hopeful we can work this out and we can put these 2 candidates, both of whom are outstanding, into these positions.
Mr. Chairman, just 20 seconds, if I may.
Senator Booker.
I know, and I talked to Senator Cotton on the floor yesterday. I'm going to do everything I can to help. I just want to continue to state this because this is important to me, and maybe it's personal because Benita Gupta is a friend. But I just want to remind the committee for the record that while some people had disagreed with her nomination, she had wide law enforcement support and continues. I just met with 2 law enforcement leaders, one of which represents, their union represents the majority of police officers of the United States of America, and they continue to believe in her and support her, and I know she is pro-law enforcement. I will work with Senator Cotton to try to get an understanding of what the situation is, but I just feel the need to continue to remind people that there were definitely objections to her nomination, but she had a tremendous bedrock of support from law enforcement agencies, organizations, and unions, and still maintains that support.
Mr. Chairman.
Senator Kennedy.
Mr. Chairman, may I suggest that at our next meeting you invite one of the senior officials from the Department of Justice to come before this committee to explain why the Department of Justice is not defending our U.S. Marshals?
Senator, of course I want that question answered. Asking for a hearing before the committee at this point may be premature. There has been a response, I believe. I think Senator Cotton.
Well, we know if we send a letter to the Department of Justice, we don't get responses, at least
No, I think he did. I think he's already received it.
So I'll say I did get a response. After 10 days, as Senator Grassley said, it was mostly just a bunch of legal gobbledygook. It gave no answer on the merits about why 1 U.S. Marshal has already had his representation denied outright, while 3 are still being strung along. I can say that all the parties involved here have heard about the one is that it's not in the interest of the United States to provide representation. Let me say that I'm not going to take that as a satisfactory answer coming from Vanita Gupta's civil division.
Well,
And I'll say secondarily, the three who have been strung along, I mean, these incidents happened almost 2 years ago. It took Merrick Garland's Department of Justice barely 3 months to find that the officer who shot Ashley Babbitt on January 6th committed no wrongdoing. Why has it taken them almost 2 years to reach a conclusion in these marshals cases, after those marshals stood on the front lines, were assaulted with lasers and ball bearings and fireworks and attacks by left-wing street militias?
Well, if I could finish, Mr. Chairman, and I don't mean to suggest that Senator Cotton shouldn't have jumped in, because I appreciate that answer. But a letter's one thing. Judging the credibility of live testimony is quite another. I would like to reassert my suggestion, Mr. Chairman, that at our next meeting, this is an urgent matter, that we invite a senior representative to the Department of Justice to come explain to us, shouldn't take long, why it is declined to represent our U.S. Marshals.
I'd like to quote from the letter that was sent to Senator Cotton. I'm looking for the date on that letter. I think it's been within the last week or two. I don't see a date on the letter.
It was yesterday.
The Senator received a response yesterday. Let me read from it so that we understand what we're talking about here. The Department of Justice strongly supports the provision of representation for federal officers acting in the line of duty. The department has received numerous representation requests in connection with official law enforcement conduct relating to the Portland protest. We are providing direct representation or paying for private counsel for over 70 federal employees in response to these requests. To date, we have denied only a single request for representation arising from these events, and 3 requests remain under review. Now, that is not gobbledygook. That is a series of declarative sentences that I think make it clear. 3 cases are being evaluated. 1 they have denied. And for that, we're going to hold up the U.S. Marshal for the Northern
Yeah, we are. We're going to
District.
hold up every department nominee.
Well, I
actually.
can just
I don't
tell you,
care. I'm
don't
glad
give
they're
it-
representing the 70. I care about the 4.
Don't give a speech about law enforcement in Northern District and any violent crime if you're holding up the law enforcement officials that are going to be given the responsibility of taking care of that issue. I could share your concerns about wanting to know what they're going to do with the 3 and why the 1 was denied. That is a legitimate concern. But to take it out on law enforcement in Illinois, for goodness sakes, or other states, Minnesota, does that show respect for law enforcement?
Mr. Chairman,
Senator Kennedy.
not to put too fine a point on it, but may I suggest that we invite the author of that letter to come to our next Judiciary Committee meeting and explain this situation?
The author is Peter Hyen, Acting Assistant Attorney General. I do not know him. I think it is appropriate to ask that he or someone he represents come before us. I don't think it has to be a formal committee meeting. Let's find out where we stand on the 4 that Senator Cotton has a question on.
Well, I would look. You're the chairman. You can decline my request, but this concerns me, and I just found out that one of those U.S. Marshals may be in Louisiana, and I think it would behoove all of us to hear together so we could all ask questions from the gentleman whose name I've already forgotten, but
Mr. Hyen.
Mr. Hyen. Justice is right across the street. Just ask him to come on over and let's hear directly.
So I would say that Peter Hyen is not the right person here. He's merely the acting assistant attorney general for legislative affairs. He's just transmitting a substantive decision that's been made, presumably by Vanita Gupta as the associate attorney general, since he oversees the civil division, which represents law enforcement officers for lawsuits in the line of duty. Again, these officers have been hung out to dry. They have no reason. The one who's been denied has been given no factual reason why he was denied representation, merely that it was in the interest of the United States.
Could we ask Ms.
I'd love to ask her.
I don't know who the appropriate person is. So let me amend my suggestion to bring the appropriate person to our next Judiciary Committee meeting to answer these questions.
I'm going to pursue this matter. We don't know the circumstances. We don't know if we're dealing with privacy issues, attorney-client privilege issues. We just don't know. We have one who's been denied. Maybe we can learn that, the facts behind that. Maybe we can't. You know, as an attorney, there are certain things that just can't, maybe wouldn't be disclosed to the public related to personnel matters and the like. So I don't want to have an open hearing, people under oath, until we've at least taken another step of asking for follow-up on this letter. 3 are under review. Perhaps they'll be decided soon.
And I understand, Mr. Chairman. May I suggest that you attempt to get that answer from the Department of Justice, and if they don't answer within 10 days, I would reassert my suggestion that we ask Ms. Gupta to come on over and tell us what's going on.
I don't know if she's the appropriate person.
Or the appropriate person.
And I would say we don't know the circumstances. These 4 marshals don't know the circumstances either. Here's what we do know. All 4 of them, all 4 are on unrestricted active duty with the Marshal Service. Now, there are cases in which the Department of Justice can legitimately decline representation if a law enforcement officer committed a serious felony in violation of clearly established law at the time that may be appropriate. But how could they possibly be denying representation to these 4 marshals and then sending them back out on unrestricted active duty?
Well, all I'm suggesting, Tom, is that this matter can be cleared up pretty quickly. I'm willing to start the meeting at 8 o'clock, whatever time you want to start it. Let's bring the appropriate person over from the Department of Justice and respectfully ask them what's going on here. Why aren't you representing these marshals? And if they say attorney-client privilege, whatever, we'll learn something.
I might also add that that letter made it clear that they would represent them for acting in the line of duty, which may be the issue. I don't know, but I will pursue it to get clarification from this letter, and we'll decide after that effort is made whether there's anything more that needs to be made. But I think that's the first reasonable request, is that they give us more information than contained in the letter that was received yesterday.
I would just ask, Mr. Chairman, that we don't allow them to rope-a-dope us. They give us an answer, and if they don't give us an answer, we think about bringing them over.
I respect that, and I'm willing to live by that standard. But to think that innocent individuals are having their appointments held up in this committee to execute the responsibility of law enforcement at a time of high crime in my state is an unacceptable pressure point. I just think it doesn't make sense. It's inconsistent to argue how much we revere law enforcement by holding up law enforcement officials that this administration wants to appoint. The question now is on the U.S. Attorney nominees and marshals before us. I understand we are going to proceed with an en bloc voice vote on the 2 U.S. Attorney nominees receiving a vote today, and separate en bloc voice vote on the 2 U.S. Marshal nominees. So on favorably reporting the nominations of Marissa Darden and Delia Smith to be U.S. Attorneys, all those in favor say aye. Aye. Those opposed, no. The majority of the members present having voted in the affirmative, the ayes have it. The nominations will be favorably reported to the floor. Next on favorably...
Mr. Chairman.
I'm sorry, I didn't. Senator Hawley recorded as no.
Mr. Chairman.
Senator Blackburn.
Record me as no.
Recorded as no. Senator Lee, no as to Marissa Darden. Any others? Senator Cruz, no for both, or which? Both. Senator Cruz is no on both. Chair repeats, the majority of members present having voted in the affirmative, the ayes have it. The nominations will be favorably reported to the floor. Next, on favorably reporting the nominations of Eddie Frizzell and LaDon Reynolds to be U.S. Marshals, all those in favor say aye. Aye. Those opposed, no. The majority of the members present having voted in the affirmative, the ayes have it. Are there any members wishing to be recorded no on those U.S. Marshals?
Lee.
Senator Lee? No on Frizzell. Senator Blackburn?
No.
On both? On both, Senator? Senator Blackburn, no on both. Any others?
Senator Cruz.
Cruz? No on both. Chair restates, the majority of members present having voted in the affirmative, the ayes have it. The nominations will be favorably reported to the floor. The final nomination is Andrew Foyce, nominated to be chairman of the Administrative Conference of the U.S., currently serves as Career Attorney Advisor in the Office of Legislative Affairs at the Administrative Office. Before that, spent several years as a Deputy Attorney General. Does anyone seek recognition on the Foist nomination? On favorably reporting the nomination of Andrew Foist to be Chairman of the Administrative Conference of the United States, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein. Aye. Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Yeah, I
Mr. Blumenthal.
Lugar was
Mr.
more
Bruno.
understandable. There were a few other people, remember the letter and they all,
Mr. Hart. Mr. Booker.
and they went in that.
Mr. Padilla. Mr. Ossoff. Mr. Grassley.
This seems like I just
Mr.
explained
Graham.
about the guy. And he left Urban's gone.
Mr. Cornyn.
Yeah,
Mr. Lee.
the other ones did both.
Mr. Cruz.
And they're just doing to stand with God.
Mr. Sachs.
His was all out of
Mr. Hawley. Mr. Cotton.
How's the Google bill
Mr.
going?
Kennedy.
No.
Mr.
How's the Google
Tillis.
bill going?
Mrs. Blackburn. Chair Durbin.
Does he
Chair
want to get
Durbin,
it
the
done?
votes are 11 yeas, 10 nays, 1 pass.
Okay. Need to have a talk with him.
Chair Durbin, the votes
I
are
just
12
hope
yeas,
there's some
10
reason.
nays.
There might be. Not in.
Nomination be favorably reported to the floor. Next up is the consideration of S 3538, the Earn It Act of 2022. My understanding is Senator Graham has to be on the floor soon, so I'm going to turn it over to him and to Senator Blumenthal to explain the bill.
Thank you, Mr. Chairman. We have taken this up before. The committee passed it unanimously. We've been working with Senator Lee for some concerns he has, and I want to just say to anybody and everybody listening, Senator Lee has been great to work with. There's never been a doubt about his desire to protect young people from having their images continuously shown, the sexual abuse that happened to them that was recorded in different forms, repeatedly shown on the internet for all of their lives. He's against that. So Section 230, as we all know, basically protects social media platforms, gives them liability protection. They say they're billboards. We've heard, Mr. Chairman, from victims of child exploitation, people as children being sexually abused has been recorded in photos and videos that are played out on the internet millions of times. And it just follows them to their grave. And so what we're saying here is when it comes to Section 230, we're going to have an exemption regarding 2 federal statutes that make it a crime to knowingly pass on sexually graphic material regarding children. So an internet social media company would be put on notice that they need to regulate this, but in terms of prosecution, they would have to knowingly engage in allowing the behavior to continue on their platforms. I think 49 states have laws regarding this subject matter. Senator Lee, we will continue to work with you to make sure that we don't do anything to put states in a bad spot or to capture the innocent. But I think the committee has spoken with one voice. I want to thank Senator Blumenthal, thank every member of this committee. It took a while to get over the hearing. Senator Feinstein and I talked about it. The examples of people having children, mothers, fathers of children that were sexually abused, and the abuse was captured in video and sometimes photos that continues forever. And our goal is to tell the social media companies, get involved and stop this crap.
Yeah.
And if you don't take responsibility for what's on your platform, then Section 230 will not be there for you. And it's never going to end until we change the game. And this bill changes the game. And I hope we can be unanimous in supporting this legislation, get it to the floor, and make it law, and do something about protecting these children other than talking about it.
Mr. Chairman,
Senator Blumenthal first.
Thanks so much, Mr. Chairman. I'm going to be brief because I'd like my full statement be entered in the record.
Without objection.
I'd also ask that letters of support from a number of organizations among the 250 law enforcement groups, child advocates, NCMEC, and others be also entered in the record without objection.
Without objection.
Let me just thank, first of all, Senator Graham for his patience and dedication to this cause, which is extraordinarily bipartisan. We have 22 co-sponsors to this measure in the Senate. And I know there is some controversy about it, but I just ask my colleagues to imagine for the moment the most unspeakable, despicable violation of your physical being that you can imagine at a young age, as a child, repeated thousands of times on the internet for millions of strangers to see with sadistic pleasure, following you through your whole life. And imagine that someone has the tools and power to stop it and basically blows you off, refuses to respond. We have heard numerous examples. 2 13-year-old boys groomed and coerced into making sexually explicit videos that later were posted on Twitter. They weren't hidden. They were posted for the whole world to see with hundreds of thousands of views and retweets. And their mother contacted the authorities, and Twitter basically said they were going to leave them up until the Department of Homeland Security intervened. Another example, Jane Doe versus Reddit. The ex-boyfriend of a 16-year-old girl recorded sexually explicit videos without her knowledge or consent and then posted them. They were taken down. He reposted them, and she was forced, in effect, to watch for the reposting again and again and again. Reddit is a $10 billion company, and there are simple, accessible, sometimes free methods for these companies to use automation to detect, whether through software or the cloud, when these images appear. Now, there's no question, big tech, their armies of lobbyists and their allies have sought to make this issue one of encryption. It's not about encryption. That is a gigantic red herring. This issue is not about free speech. Rape is not free speech. And there are companies that actually are consistent and vigorous partners in this effort because they know it is possible to stop it with little or no cost. Now, this bill is more than just about Section 230. The Internet Act will stop exploitation before it starts by expanding mandatory reporting to include the enticement and trafficking of children. It will, second, assist prosecutors and law enforcement by doubling the time that tech companies are legally required to preserve evidence of exploitation. It helps law enforcement more quickly recover sexually exploited children and remove them from harm. It fosters the next generation of technologies to stop exploitation. And it does hold tech companies accountable when they fail survivors and they enable these predators to spread the kind of child sexual abuse material that is so egregious. The tech companies say, well, the answer is more resources, more money, more investigators. Yes, there should be more money, more resources, more investigators. But law enforcement itself says they need this statute. there are 250 child advocacy organizations, law enforcement organizations, such as the National Association of Police Organizations, Major Cities Police Chiefs Association, the National Center for Missing and Exploited Children has helped lead this effort. In fact, reported that they received 29.3 million reports of child sexual abuse material. 29.3 million. 29.3 million faces, voices, individual children coerced into this kind of activity, their images forever on the internet. So I ask my colleagues to support this measure. It is a narrow carve-out to Section 230 that simply holds accountable big tech with a knowledge standard requiring that it know about it, that is responsible and carefully crafted. We've worked with colleagues like Senator Leahy in his very constructive objections. We continue to work with colleagues such as Senator Lee and Senator Ossoff. We're more than happy to continue this effort as we go to the floor. I ask my colleagues to support this measure.
I have several members who sought recognition, Senator Feinstein and Senator Coons. But before I recognize them, I'd like to ask either Senator Blumenthal or Graham for clarification. I'm a co-sponsor. I don't disagree with anything you've said. But as a result of this change in Section 230, would these tech companies have a duty to reasonably inspect material that is being published on their websites to determine whether it is in violation of this legislation which we're considering?
There's no express duty in the statute, but if they have knowledge of it, they can be held accountable.
Mr. Chairman, you bring up should they have a duty? That's a different discussion for a different day. But right now, all we're saying is there are laws on the books that make it a crime to knowingly pass along sexually explicit material regarding minors. It happens every day, millions of times each day on social media platforms. When they're informed, we hope they will act responsibly. But maybe the committee will consider a separate course of action to say you have an affirmative duty. That's not in this bill, but it may be in my next bill. Thank you for bringing it up.
Well, it raises a question. If we are establishing civil liability, it is usually a breach of some duty that leads to that liability. And so is there some refuge for Facebook and Twitter to say, we just never look. We don't know what's being published?
This is a criminal statute. This is not civil liability.
It's civil as well, I believe.
Yeah, well.
Is it not?
Mr. Chairman, there is a duty that can be violated and that would give rise to civil liability, which is the knowing spread, if it's reported to them. The two examples I've given, one involving Twitter, the other involving Reddit, where they were clearly informed and essentially refused to act responsibly.
So the case that you've described of the young woman who was being exploited and things were being posted and then reposted, in that circumstance, they clearly had knowledge if it's being reposted and there's already been an objection to it. The question is whether they have an obligation, I'm asking whether they have an obligation at the outset for those things that are submitted and published online to review them before they allow their tech companies to be a platform for that publication.
There is no express duty for them to undertake that kind of review. In my view, of course, there is a moral responsibility here, and I'm happy to work with the chairman on a statute that Senator Graham has said maybe is for another day. This measure is very narrowly, carefully crafted to impose a legal responsibility with a standard of knowledge giving rise to criminal intent that in turn can be the basis for civil accountability. It gives these victims and survivors, as well as state attorneys general, a day in court, access to our justice system, so they can create an incentive for these companies to do the right thing. When they are told by the mother of two 13-year-old boys or by the victim and survivor of a boyfriend who displays sexually explicit photos on the internet, they have a responsibility under this statute.
I'd just add, I'm going to stop because others are seeking recognition, but Section 5 of this bill relates to civil liability as well, and it specifies the statute where the civil action can be brought, Section 2255 of Title 18, and then another more general civil action as well. So it's not just the criminal charge, but it's civil liability as I read it.
Mr. Chairman, would Senator Blumenthal yield for a question?
Happy to ask him.
I will, sure.
Senator, I want to be sure I understand what you're saying. You're saying in the instances you cited that the people being exploited, or in the case of a minor, their parents, contacted Twitter and Reddit and said, look at the look at the pictures, look at the photographs. And Twitter and Reddit did, and then did nothing. Is that what you're saying?
Yes.
Thank you.
Senator Feinstein, Coons, and Lee, and Cruz, and Blackburn. You're recognized. Senator Feinstein.
This, I think, is really important, and I want to really congratulate the authors. I didn't know that there was a blanket immunity in this area of the law. And so what we have is a growing problem of sexual abuse of minors on the internet. And this bill takes a targeted approach by removing that blanket immunity under Section 230 for violations of law related to online child sexual abuse. It seems to me that this is pretty direct and pretty real, and I want to congratulate Senators Blumenthal and Graham, and I really don't understand any opposition to it because it's the most direct, simplest solution. Take away the blanket immunity.
Thank you, Senator. Senator Coons. Senator Coons stepped out for a moment. Senator Lee.
Thank you very much, Mr. Chairman. I do want to thank Senator Graham and Senator Blumenthal for their efforts to combat child sexual abuse material. This material is a scourge to society in any format, and it's proven especially virulent and difficult to combat online. And I know that every single member of this committee, myself included, we're all united in our desire to eliminate it. And they've worked hard, faithfully, in this Congress and in the last to do that. Now, in the last Congress, Senators Graham and Blumenthal effectively addressed many of the concerns that had previously been raised with the legislation before we marked up the Earn It Act. I subsequently voted for the legislation while reserving my right to continue to refine it once it left the committee, and with some assurance from the sponsors and from Senator Graham, who was the chairman, I believe, at the time, that they'd continue to work with me in good faith to address some of the lingering issues. It is important, not in spite of, but specifically because of, the fact that we all support this. It's important to get it right. It's important when we act to make sure that we know what we're enacting. Particularly with something that's this popular and as to which there's this much support and this much passionate support. We have a duty to those we represent. We have a duty to the American people and to our legal system to make sure that we understand what it is that we're enacting. And I want to highlight a couple of things that I've identified and that I continue to want to make sure that we understand completely before we act. because I think we're very close. I don't think we're quite there yet, but I think we're very close, and I think this is something we can move out of committee today. But I do think we need to have a plan to address a couple of things. It's unfortunate, by the way, that we can't, a trend seems to be developing, particularly with some things that are popular and as to which there's a fair amount of emotion, that we seem to have fallen out of the practice recently in the committee of welcoming efforts to improve legislation at markup. There were some unfortunate things said by offices of members of this committee over the last 24 hours that have falsely sent the signal that there are some members of this committee who don't support the legislation or that are wanting to tank it for one reason or another. That is unfortunate. That there were communications made to some outside groups, and some outside groups who ended up interpreting the filing of amendments last night as somehow a hostile act. We filed those consistent with longstanding practice of this committee, that we file those by 5 p.m. the day before the markup. And I mean, this is the place where that happens. It's at markup when we improve any latent, lingering misunderstandings, we clarify things, we make modifications to it. I want to cover a couple of issues where I have concerns. First, I've got some concerns with the encryption component of the bill, and wish that this version fully reflected the compromise reached by the committee in the last Congress in response to changes that were requested by Senator Leahy. The reason I raise that is because I'm a little concerned that the current language inadvertently mandates interactive computer services to do for the government what the government itself is prohibited from doing, which is engaging in sort of the open-ended policing, the accessing and then reporting of private and protected data without the protections of the law. I've got an amendment that would restore the Leahy language, which I think struck an appropriate compromise here, and that's an amendment that passed this committee by unanimous consent in the last Congress. I don't necessarily have to ask for a vote on that in committee today, but I will be asking that we continue to work on this issue as we approach the floor, because I think it's important. If there's a reason why that was omitted from this, I'd love to know what it was, but it concerns me. I don't see a good reason to omit it. There are a couple of different formulations that I've proposed, one of which involves the Leahy language itself. I've got another one that would just involve the striking of one word and the elimination of one letter of another word, and I think that would also fix it. I'm open to other ideas. I'm also open to arguments if you think I've got that issue wrong, but I want to make sure we know what we're doing when we enact this. We owe it to the American people to be thorough. My other concern relates to the provisions of this bill dealing specifically with Section 230 of the Communications Decency Act. Now, I wholeheartedly agree, not only with the overall objectives of this bill, but I wholeheartedly agree also that interactive computer services complicit in the advertisement, promotion, presentation, distribution, or solicitation of child sexual abuse material should not enjoy protections under Section 230. But if we've learned anything from watching Facebook, Google, and Twitter over the course of the pandemic and a controversial presidential campaign cycle and what's followed from it, it's that those particular actors, the really big ones, perhaps not the smaller actors, but certainly these larger companies, can and do thoroughly monitor, and they have full capacity to identify and delete posts and suspend individual accounts that they deem problematic, undesirable, or otherwise not appropriate for their site. If these big actors fail to be as vigilant as they've been in other contexts, if they fail to be as vigilant in using these capabilities in their efforts to combat child sexual abuse material as they have been in stifling other views that they don't like, whether it's about alternative COVID therapies or conservative viewpoints or whatever it is, then I have no problem with them being held liable for not addressing CSAM on their sites. They certainly have demonstrated the ability to thoroughly monitor their sites and address things that they find unacceptable. And so if they have that in other areas, they certainly have the ability to do that with respect to CSAM. But unlike alternative COVID therapies, CSAM is actually illegal. And so they ought to be able to do that. At the same time, I do worry about smaller companies. Smaller companies in particular that might not have the resources to comply with the patchwork quilt of state laws. And I also worry that these smaller interactive websites, including things like a church website that allows people to chat online about their about theology or about tenets of their faith. I worry about something that might happen there with regard to sites like that might unwittingly fall liable under the laws of an overly aggressive state. Now, to be clear what I'm talking about, if you turn to Section 5, I'm talking about Section 5B and Section 5C. You'll find this on page 15. It's significant that both of our sponsors, and I think this shows that there really is great agreement here, that we do not disagree on the substantive merits of it. We've heard from Senator Graham and from Senator Blumenthal repeatedly about the fact that this adopts a knowing standard. We're dealing with a knowing mens rea, and I think that is the appropriate place for us to dwell. That is, in fact, what we're talking about, and it's what we should be talking about. They're not wanting to make it negligence or strict liability or anything else. But in Section 5B and Section 5C, on page 15, starting at line 16, you've got incorporation by reference to civil and criminal liability as provided for by state law. Now, this is great in most ways because, if I'm not mistaken, 49 out of the 50 states have laws. The laws cross-referenced and incorporated by reference in Sections 5B and 5C themselves have a knowing mens rea requirement. There's one state that has something lower than that. I think it's a type of recklessness standard. But my point is this. The legislation is written, while intended, I think, in good faith by the sponsors, Senator Blumenthal and Senator Graham, to apply to a knowing mens rea standard. This doesn't prohibit the allowance of a lower mens rea standard. In theory, in fact, under Sections 5B and 5C, even if a state, let's say if the state of New York, for example, decided to adopt a strict liability standard, then all of a sudden that would be incorporated by reference into this component of this federal law. And so this is an issue. Because under this law, if a state, let's say New York, enacted a law saying that any interactive service provider, regardless of other circumstances, that doesn't remove CSAM within 1 hour of being posted is liable for damages up to $1 million. Strict liability, in effect. A church with that type of interactive website where individuals could post on their religious beliefs or whatever it was could be strictly liable under that New York law if someone posted CSAM on that website, even if it was without their knowledge during that time period. Now, I don't think that's the intent of either of the lead sponsors on this. In fact, we know that it's not because they've told us that today. They've repeatedly stated that it's a knowing mens rea standard that would be applied here. Now, this is not to say, none of this is to suggest that even smaller companies or even the church website I described should enjoy CSAM protections if they're knowingly complicit in presenting or distributing CSAM. So I support lifting Section 230 liability protections if anyone does that, if they knowingly allow for the distribution of CSAM. To do that effectively, we need to base this federal protection on standards that are discernible and navigable for all interactive computer service providers. Look, the internet is inherently interstate. It falls into the category of channels and instrumentalities of interstate commerce over which we have regulatory jurisdiction through the Commerce Clause. Section 230 is a federal liability protection. For the Earn It Act to work, it should, at the very least, have some nexus to a federal intent standard that doesn't allow this loophole whereby a state, through the back door, can work in a lower mens rea standard as necessary to trigger these provisions. And so I've got an amendment on this, and the amendment would abrogate the 230 protections when CSAM cases are brought against ISPs under state law, so long as the underlying offense would constitute an offense under federal law. In this way, we can successfully tie federal liability protection to federal standards. And it would allow smaller ISPs to know what's required of them to act responsibly to remove CSAM as a condition for receiving Section 230 liability protection. Yeah, I'll be wrapping it up. So we may find that federal mens rea is too, if this is the wrong standard one way or another, we need to have that discussion about what standard it is that we're talking about. If you want to adopt a different standard, let's have that conversation. But let's not leave it open through the back door for a state to do it. No state, to be clear, has adopted a strict liability standard or anything like that. But under this, we leave that open, and I think we need to address it. So look, the hour is late, and I especially now that I've heard the intentions of both the authors, I'm confident that we actually agree on this. So if you're good with it, if you agree to work with me in good faith as we approach the floor to address these issues, I'd love nothing more than to support moving this out of committee today.
Senator Lee, let me just say two things. First, if you ever want to offer an amendment, you are welcome to do so, as any member of the committee would be. I have done my level best to open that opportunity and not close it to either side of the aisle. So that is your right. Secondly, when you say all but one state, which you've referred to in mens rea, the one state is my state, Illinois, and they have established a standard, a mens rea standard of knew or should have known. So they've gone beyond the strict knowledge standard to a responsibility of having to learn the situation. That's why I asked the question of Senator Blumenthal. Senator, did you want to speak?
Yeah, I'll just respond really briefly. As the senator knows, the treatment of encryption in this statute is the result of hours, days of consultation involving the very wise and significant counsel from Senator Leahy, who offered the original encryption amendment and said at the time that his amendment would not prevent tech companies from being held liable, quote, for doing anything illegal, for doing anything that would give rise to liability today, for using encryption to further illegal activity. That's the key distinction here. Doesn't prohibit use of encryption, doesn't create liability for using encryption, but the misuse of encryption to further illegal activity is what gives rise to liability here. That's the very simple answer, and I'm happy to continue the conversation that we've engaged in so far. And on the issue of different standards, possibly in different states, you're absolutely right, Senator Lee. 49 states use the knowledge standard. One uses a recklessness standard. Happens to be that state is Illinois. Other states may wish to follow Illinois. And as Justice Brandeis said, states are the laboratories of democracy. One of the most often quoted, I think, Supreme Court comments in history. And as a former state attorney general, I welcome states using that flexibility, and I would be loath to straitjacket them in their adoption of different standards. But I'm happy to work with my colleague and friend, the senator from Utah.
Thank you. We have two more requests for comment, Senator Coons and Senator Cruz.
Thank you, Chairman.
Senator Ossoff.
Thank you, Senator Blumenthal, Senator Graham, for your good work on this and for your comments. I will on Monday be visiting the Child Advocacy Center in Delaware that I long supported, was a partner with both in my service here in the Senate and in my previous role as county executive. This is a center that provides counseling, support, forensic interviews for victims of child sexual abuse. It is a horrific place to have to go. To talk to the staff, to encourage them and support them in their work is just a reminder of how difficult this issue is. We all know families who've been directly impacted by child sexual abuse, and the internet has sadly facilitated the spread of horrifying images and the re-victimization of people who have suffered this. So I have two folders, one full of letters from law enforcement, from child advocacy organizations urging that we take this up and pass it, and the other from organizations I also respect and work with, human rights organizations, civil rights organizations, Consumer Reports, urging me to oppose it. I voted this bill out in the last Congress. I will vote it out again today, but I remain concerned about some of the provisions around encryption and how it may impact domestic violence victims in this country, human rights advocates and journalists overseas, and I'm trying to make sure, Mr. Chairman, and to my colleague, Senator Durbin, that as we proceed, that we proceed carefully. We legislate rarely in complex issues around technology and privacy here, and in some cases, we do not legislate particularly well. I am hopeful that this will send a strong signal that technology companies that are already doing a fair amount to try and combat child sexual abuse material on their platforms need to do more. And frankly, that we need to invest more in law enforcement. When I consulted law enforcement in Delaware, they are simply overwhelmed with the volume of the content that they are being provided to try and investigate and follow up on. So with those comments, I look forward to working with the sponsors to continue to refine and improve this legislation before it finally makes it to the floor for enactment. But I will vote in support of this legislation getting out of the committee today. Thank you, Mr. Chairman.
We have in the queue Senator Cruz and Senator Ossoff. Senator Cruz.
Thank you, Mr. Chairman. I want to thank Senator Graham and Senator Blumenthal for their hard work on this bill. It is an important issue. It is an issue we all care about. I also want to thank Senator Lee for his very diligent efforts to try to make sure the bill operates properly and effectively. I very briefly just ask unanimous consent that I be added as a co-sponsor to the bill. And I also ask unanimous consent that I be recorded as voting present on the judicial nominees earlier today. Thank you.
Chairman.
Thank you, Mr. Chairman. Similarly, echoing Senator Cruz, want to commend Senators Blumenthal and Graham and the other co-sponsors for their continued efforts to combat this scourge of child sex abuse material online. As did Senator Cruz, thank Senator Lee for his diligent engagement in this markup and attention to detail. And as this discussion continues and the issues raised by Senators Lee and Coons are addressed in the discussions that will unfold as this legislation proceeds toward the floor, I'd like, Mr. Chairman, to enter into the record to ensure that we're fully informed by all those who have made suggestions with respect to this legislation, letters from or co-signed by the following organizations, including the Center for Democracy and Technology, the Electronic Frontier Foundation, the Human Rights Campaign, the Mozilla Foundation, the Society of Professional Journalists, and the Wikimedia Foundation.
Without objection.
Thank you, Mr. Chairman, and I'll just thank again the bill's sponsors and Senator Blumenthal for your commitment to work with the members of this committee as this bill proceeds to ensure that we avoid any unintended consequences that could negatively impact the privacy or security of users of online services.
Chairman.
Thank you, Senator. We have two senators seeking recognition, Booker and Leahy. Senator Booker.
Third. I would like to just defer to Whitehouse, whose hand was up before me.
Senator Whitehouse.
I'll be extremely brief. I applaud this measure and intend to support it. But I think it would be useful for this committee to take a broader look at the merits and demerits of Section 230 entirely. The internet and the big platforms have gone through radical transformations since the section was first put into place, and I think it's a conversation well worth having. Thank you.
We have Senator Leahy and then Senator Klobuchar.
Thank you very, very much. And I've worked closely on a lot of these encryption matters with Senator Lee and others here, Senator Blumenthal. He knows my former chief counsel, Mr. Pendle, worked hard on this. There is we negotiated some language on encryption, which is included in the act, about going against sexual abuse material, not ending encryption services, which protect privacy and data security. I think the updated language does that. We try to strike the right balance between the need to target child sexual abuse and also, though, to preserve privacy protections. I believe it has. I know there's going to be further work as we're going through, but I commend the senators on both sides of the aisle who worked so hard in this. And Senator Blumenthal, you've been extraordinary in the amount of work you've done on it. And as Senator Coons pointed out, you can get letters for and against, but we know this is a very, very important subject, and I think it's workable. Senator Lee and I have discussed it even again late last night, and Senator Ossoff and I, and it can be done.
Senators Klobuchar and Padilla. Senator Booker, did you?
Yes, I'd like to go at some point, but the updais people who have far more seniority.
Oh, my goodness.
should certainly go first.
Speaking from the updais, thank you, Chairman Durbin. Thank you, Senator Booker. I just wanted to commend, of course, Senator Blumenthal and Senator Graham for their incredible work on this and sharing some of the sentiment that Senator Whitehouse just raised about, in addition to moving forward with this and some of the other work we've done on human trafficking in Section 230, is really looking at it as a whole. And I wasn't in this space a few years ago, but as I have encountered working with Senator Lee on the venue bill, where he's worked so hard leading that bill, and the resistance that we got on that from the companies to simply allow the state attorney generals to be able to keep their cases in their own states and not be delayed, or the work that and the resistance we got from the companies of even doing that. Senator Grassley and I, the work that we did on the are doing on the self-preferencing anti-discrimination bill. Just one thing after another, you make a change, then another one, and they just are basically resisting any attempt to make a fair and even playing field on the internet. You look at the work that Senator Blumenthal and Senator Blackburn did, and I was happy to be the original co-sponsor with them on the App Store. Again, resistance. You look at the work that Senator Kennedy and I have done on the journalism bill. Every step of the way, regardless of differences on this committee, there's one thing in common with all these efforts, even if we don't agree on them, and that is just a resistance to this. And that's why I am very pleased with Senator Whitehouse's remarks to look at Section 230, because at some point, you know, you can't resist any effort in this huge part of the economy where there have been people hurt in so many different ways and small businesses hurt of any kind of rules of the road, and yet they hold up this immunity. So it's time to look at it, and I commend my colleagues for their work.
Going down dais, Senator Booker and then Senator Padilla.
Very far down. Thank you very much, sir. I just want to again thank the sponsors of this bill. This is a moral urgency that we, as a Senate, take an action to a grave and, as Senator Coons described, wretched problem within our country. I just want to just sort of, in honor of the time, just affiliate myself a bit with the concerns that were expressed by Coons and Ossoff and Lee, and let the sponsors of the bill, I know I would really like to work with them to see if we can find as best of balance as possible on some of the concerns that the civil rights community and, excuse me, that the human rights community and privacy rights communities have. But thank you.
Thanks, Senator Booker. Senator Padilla.
Thank you, Mr. Chair. I'll too try to be brief and add on to comments expressed by Senator Booker, Senator Ossoff, Lee, and others. I want to thank the leaders of this legislation. I also want to thank the survivors and child safety organizations that have reached out to my office to shed light on the clearly inadequate responses of both tech companies and law enforcement to address the crime of child sexual abuse. We should be investing more in protecting our children, in helping victims recover after unspeakable traumas, and holding the perpetrators and enablers of their abuse accountable. The tech industry certainly has the resources and capabilities to invest more in keeping our children safe online. And I fear that without the presence of this legislation, the companies might not be doing as much as they're doing on this front, but we clearly need to do more. I also think it's important to note, as Senator Ossoff has raised, that dozens of human rights organizations have expressed significant concerns with the bill as written. They warn that the bill could result in the overbroad censorship of lawful speech and activity in a manner that will disproportionately burden diverse communities, particularly the LGBTQ community. They've also raised concerns that the bill could actually jeopardize public safety by disincentivizing companies from offering end-to-end encryption and other privacy and security technologies. So I just urge the sponsors to work with these organizations and human rights groups to address the concerns before the bill reaches the floor. Again, thank you to Senator Blumenthal for his work on this important issue. Thank you, Mr. Chair.
Thank you. If no one else seeks recognition, we'll vote on final passage on favorably reporting S35.
Chairman, if I could just make one final comment here.
Certainly.
Very quickly, I want to second the remarks made by Senators Whitehouse and Klobuchar. Very pertinent and important that this approach is very narrowly targeted. We're carving out an exception, but I hope we will review Section 230 as a whole and the immunity, the broad immunity, and now arguably very unnecessary immunity that we give to big tech. Second, I urge my colleagues to look at this issue of child abuse. I've heard Senator Booker very powerfully and eloquently describe the shootings that occur in his own neighborhood, the crime that occurs throughout this country. The statistics are overwhelming that those perpetrators have suffered some kind of abuse. It is an epidemic, and it leaves lasting effects. The literature shows that it changes the mental wiring of victims and survivors of child abuse. It changes them physically in ways that need treatment. And this bill is a start toward trying to hold accountable anyone who profits from them.
Yeah, if I may just respond, and not getting personal, but survivors of sexual trauma have the kind of deep harm of which you speak, and I know this from my own life experience with people close to me, and we must do something. That's why I applaud the urgency of your actions, and I'm just looking forward to doing the work between now and the floor to see if we can mediate against some of the legitimate concerns that I hear from the privacy community. But dear God, we are a nation that needs to do so much more, because this is far more widespread than people actually know and believe and understand, and what the current state of play has got to change, and I'm grateful for your leadership in this space.
Senator Hirono.
Mr. Chairman, very briefly, there is bipartisan concern about Section 230 immunity, so I appreciate the extensive discussion we've had regarding this bill and the various carve-outs that we've been contemplating, and so I hope that this committee will be open to addressing other instances where Section 230 immunity should not apply. For example, if one's civil rights are violated, or if there's a wrongful death that can be shown. And I think this just points out that the broad immunity of Section 230 needs to be addressed, and we are doing so. Thank you, Mr. Chairman, and to the sponsors of this bill.
Thanks, Senator Hirono. I'll wrap up by saying the exchange between Senator Blumenthal and Booker called to mind my visit to the Cook County Juvenile Facility to ask the counselors who were these shooters who were killing so many people on the streets of Chicago. They said, well, they display about every possible challenge and mental illness, but there's one thing they have in common. Over 90% of them have been victims of trauma. And of course, that refers to adverse childhood experiences which go beyond physical trauma. So I couldn't agree with you more. We wonder how kids can come to the earth in the usual way and turn out to be killers by the time they've reached the age of 10 or 11. And sadly, we know what the background is. They've been exposed to things which many of us, thank God, have never had to face. But they are, many of them, salvageable and redeemable if we put in the effort and identify their concerns. I'm going to try to move to the passage of these two bills at this point. On favorably reporting 3538, the Earn It Act of 2022. All those in favor say aye.
Aye.
Opposed, no. The majority of the members present having voted in the affirmative, the ayes have it. The bill will be favorably reported to the floor. Next is S3103, co-sponsored by myself, Senator Blackburn, and many others, to provide greater access to justice for child sex abuse victims by eliminating the statute of limitations for the federal civil remedy. The hearing we had with Olympic athletes is still being talked about, where we heard about Dr. Nasser, who for decades was abusing these children. There is no statute of limitation for federal criminal prosecution of child sex abusers while the victim is alive, but statutes of limitations remain an obstacle for many survivors. Recently, a study by Child USA of the survivors of abuse in Boy Scouts of America found that 51% of the survivors disclosed their abuse after they'd reached the age of 50. This is trying to remedy the situation by extending the statute of limitations, I should say waiving the statute of limitations under these circumstances. Is there any discussion of this bill? If not, we'll vote on final passage on favorably reporting S3103, eliminating limits to justice for child sex abuse victims. Those in favor say aye.
Aye.
Those opposed, no. Majority of members present having voted in the affirmative, the ayes have it. The bill will be favorably reported. And with that, the Senate Judiciary Committee stands adjourned. I want to personally thank the members for their patience today. We got a lot done. Glad you stayed with it.